Good afternoon, everyone. Thank you for joining this joint Sive, Paget, and Riesel Bousquet Holstein webinar. We're here today to talk about DEC's December 31st, 2005 amendments to the Part 375 regulations that govern the New York State remedial programs, including the Brownfield Cleanup Program, the State Superfund Program, and others. Today, we're going to focus on some of the key changes to the BCP regulations and their implications for real estate developers and BCP practitioners. Just a quick note that we are recording today, so your continued participation in this webinar will be deemed your consent to being recorded. We'll start with some introductions. My name is Jen Coughlin. I'm a principal at Sive, Paget, and Riesel. My practice focuses on project development, including environmental impact review, permitting, site remediation under the BCP, and some environmental litigation. I'm going to be the moderator for today's discussion, and I'm very excited to introduce our panelists to you, hopefully probably familiar to you already. Phil Bousquet is a founding member of Bousquet Holstein and a leading authority on New York State BCP and the associated tax credits. With over 2 decades of experience in the program since its beginning, Phil has advised developers, municipalities, investors, and financial institutions on leveraging BCP tax credits and other economic development tools to facilitate project development. We also have Aaron Records from Bousquet Holstein, who is a leading practitioner for the BCP and related tax incentives. Aaron also advises developers, investors, and project stakeholders on structuring and maximizing BCP tax credits and other economic development tools to advance complex redevelopment projects across the state. We also have my colleague, Kevin Rogers, with us today, who is a fabulous associate here at Sive, Paget, and Riesel, whose practice focuses on hazardous substances remediation and environmental due diligence and litigation. Kevin is a former geologist who has extensive experience with the BCP and has successfully advised developers in taking dozens of sites through the program. I'm going to start with some of the formalities here. The content of this webinar is for informational purposes only and should not be considered legal advice. The views and opinions expressed in them are those of the speakers in their individual capacities, do not necessarily reflect the views or opinions of their respective firms and/or any of the clients that they represent. We hope that this is going to be a conversation and not just a presentation. So we do not have a formal slideshow for you today. We're going to engage in a chat about what we see as the key developments with respect to these regulation changes. We have a Q&A chat function available. So if you have questions in real time, please, put them in there. I'll be trying to moderate to advance questions to our panelists throughout the program. And we're also going to reserve about 30 minutes at the end for a roundtable discussion. So at that point, you can raise your hand digitally. We'll unmute your microphone. You can ask whatever questions you have, and we can sort of engage in a dialogue that way. We may not get to all the questions that folks have today. We hope this is going to be a very interactive presentation, but certainly you can feel free to reach out to any of us if you have follow-up questions after the program today. So I think we'll start with a little bit of the history of how we got here, because I think many of us were quite surprised on New Year's Eve to see that these regulations had been promulgated and effective immediately. Which maybe we shouldn't have been, because there's sort of a long and tortured history to these amendments. So maybe Kevin and Phil, if you want to take us through how we got here.
Yeah, Phil, you want to start?
I'm happy to start. I guess being the eldest, I'll kick this off. So as everybody knows, the Brownfield program was enacted back in 2003. It was really a sea change to environmental remediation programs, and the combination of environmental remediation with redevelopment and very, very, very powerful tax incentives for that was, immediately, drew a lot of attention in the development community and the environmental community, and elsewhere around the state to brownfields. All a good thing. It took the DEC a couple of years to publish regulations interpreting the provisions. They were instructed to do that by statute, and they did in 2006. There was a lot of other guidance that was also issued alongside, which is outside the scope of this discussion. but the regs carried forward. The law was changed in 2008, but primarily to effectuate tax law changes. So the Part 375 regulations that we're talking about are on the environmental side of the program, not on the tax credit side of the program. There's obviously an interplay, but it wasn't until 2015 when what we call Generation 3 tax credit regime and some substantive environmental law changes were enacted as part of the 2015 extension and renewal of the Brownfield program, that the Part 375 regulations needed to be updated. One of the key changes in 2015 for New York City projects was requiring gates or eligibility criteria that were essentially administered and governed by DEC process for sites in New York City and in other cases elsewhere as well. But principally, there were gates for tangible credit eligibility that taxpayers needed to get through, and DEC was instructed to promulgate amendments to the regulations to accommodate those gates, which they did. They issued a definition of affordable housing project, which is still in effect today with some changes from 2022, and a definition of what it means to be an underutilized site. So those regulations were promulgated then. There was a lot of discussion by DEC of publishing additional conforming amendments to the Part 375 regs to conform to Gen 3 legislation, the changes to the environmental conservation law. DEC leadership spoke at a Brownfield, the annual Brownfield scheduling conference in May of 2017, where they presented some of their thoughts about what the new regulations would look like, including the gateway restrictions, including a new reaction to a provision in the 2015 tax law change that redefined site preparation costs with respect to cover systems. And they talked a little bit about what a cover system would be in this presentation, and then and promised that the regs would be, proposed by December of that year or early in 2018. There weren't any. There weren't any the next year. There weren't any the next year. Finally, but what was happening in practice is that, there was administrative practice that was based on what they had been talking about in those presentations. The tax department on audit of brownfield tax credits had also been implementing some aspects of what DEC had presented, including essentially limiting the eligible scope of site cover systems to 1 or 2 feet of clean fill, depending on if your site's non-residential or residential. So there were some aspects of what DEC had been contemplating that were implemented in practice without any published proposed regs. Finally, in December of 2021, DEC published a full comprehensive set of proposed changes to the regs. Everybody kind of was appreciative of getting that, that New Year's present from DEC on December 22nd. And there was a lot of discussion and a great deal of public comment. The Bar Association commented, the New York City Brownfield Partnership commented, a number of other organizations, stakeholder organizations commented about the proposed regs. And then they were republished with some fairly significant changes, which we're going to focus on in this panel discussion on Valentine's Day of 2024. So there was about a 2-year period of public comment. Most of 22 and 2023 was the public comment period and back and forth. And then in 2024, the DEC essentially republished an entirely different set in many respects of proposed regs. And I'll turn that over to Kevin to see if you have anything more to add to that background.
Yeah, one other thing was in 2022, the legislature enacted some additional amendments to the BCP statute, which notably imposed the $50,000 administrative fee due upon acceptance into the program. And also another important part was extending the effective sunset of the program by another 10 years until December 2032 for sites getting admitted and December 36 for sites completing COC to be able to claim tax credits. So As Phil described, a lot of these practices that are now codified in the current regulations have developed administratively and were, implemented over the past decade ahead of their formal codification. So a lot of aspects are not necessarily surprises, but there are some new changes, some new and noteworthy changes to discuss today. And so the current regs were first noticed in February 2024. Which were, intended to conform the regulations to both further conform them with the 2015 statutory amendments as well as the 2022 statutory amendments, and codify some of these administrative positions that had developed organically over the past decade. This February 2024 proposal received a lot of public feedback during this public comment period. And then in October 2024, DEC issued a revised rulemaking, which was substantively identical to the February version, except that they had updated a couple of soil cleanup objectives, which were identified to them as being inconsistent with other documents in the public comment period. And so they updated those SCAs, but otherwise issued the February 2024 proposal exactly the same in October 2024. And then the saga continues because then that February/October 2024 proposal expired under the State Administrative Procedure Act in May 2025. And so we were waiting for these regs to become effective. It seemed like DEC had committed to, this kind of proposal, but following the expiration under the State Administrative Procedure Act, they had to renotice the rulemaking in July 25, restarted the SAPA process, and the 2025 proposal was the same as the 2024 proposal, just with more administrative procedure steps in the middle. And so those are the final Part 375 amendments, which were made effective at the end of last year. And as Jen mentioned, they took effect immediately, closing this, 10-year, 15-year saga to get to new regulations.
Thank you for that history. So there are a number of meaningful changes in these regs. I think one of the first ones we would like to talk about today is the shift from conditional track 1 and how that will affect the way that folks are evaluating both site eligibility or remedial timelines, and how it impacts the potential tax credits that are available. So Kevin, if you want to start with sort of the remedial aspects, and then maybe our colleagues from Bousquet Holstein can jump in on the tax credit side.
So it's just like a very brief refresher. There are remedial tracks in the Brownfield Cleanup Program. Track 1 is unrestricted use, meaning the cleanest, allowing you to do anything with the property. And then there are restricted use tracks, restricted residential, commercial, industrial use, and the restricted tracks are track 2, track 3, which is almost never used, and track 4. They all have different amounts, different requirements for the amount of remediation work that you have to complete based on track, and then the end use, restricted residential, commercial, industrial, they set the cleanup standards you have to achieve, the soil cleanup objectives, for example. So under former Part 375, there was no such thing as a conditional track 1 in the regulations. This was an administrative construct which had developed while DEC was implementing the former regulations, because to achieve a track 1 remedy, you have to have unrestricted use, and you have to have met regulatory standards for soil, groundwater, and soil vapor at the time of COC for a quote-unquote true track 1. However, the regulations also allowed for track 1 remedies to have quote-unquote short-term institutional and engineering controls, which would manage residual groundwater or soil vapor contamination following completion of the bulk of the remedy, the soil cleanup. And so DEC created this conditional track 1 option to account for those short-term institutional and engineering control tails that they needed to manage. And so in the conditional track 1 under the former regulations, you had to achieve the soil remedy to unrestricted use at the time of your COC, but you had to designate a quote fallback track, typically track 2, where if you were unable to demonstrate to DEC that you had dealt with the residual groundwater or soil vapor contamination within 5 years of the COC, then you would have this fallback track to revert to. But if you were successfully able to demonstrate that groundwater and soil vapor met standards, then DEC would remove the conditional aspect and you would have a true track 1 confirmed. Now, new Part 375 replaces this framework with a different structure. A site which would have received a conditional track 1 COC under the former regulations will now receive a conditional track 2 COC, meaning that there are lots of tax credit implications of that, which I will let Phil and Aaron discuss. But essentially, now the way the program works is you're going to receive a conditional track 2. You still have that 5 years following the COC to complete to get soil vapor and groundwater contamination below standards. And if you successfully demonstrate that to DEC, you can petition DEC to upgrade your conditional track 2 COC to a modified track 1. And an important part is that DEC views you as having achieved a track 2 remedy at the time of COC issuance until DEC upgrades your COC to modified track 1. So you are in fact getting a track 2 COC in the first instance. It's not going to be a track 1 like under the former regime. So I think that's a good basic overview. But there are lots of tax credit implications for this, and maybe Phil and Aaron, you want to talk on those?
Yeah. I do want to ask a question that maybe the audience might like to hear. Can you just give a quick example of, like, if I'm a developer, what does it look like to me if I'm back in the before times under the old regs? I'm being told, well, I'm not going to get a clean track 1 COC. There's a condition. Like, what am I thinking? What do I have to do environmentally to the site? Because I feel like I've cleaned up a site, but I have to do what?
Yes. Yeah. So, to achieve track 1, you have to meet soil, groundwater, and soil vapor standards. So for a conditional track 1, that means you have achieved the soil unrestricted use standard site-wide through all depths, and therefore you have presumably removed the bulk of on-site contamination in the soil. However, groundwater and soil vapor conditions may improve. Their improvement may lag behind the completion of the soil remedy due to natural attenuation, due to other short-term controls that might be in use. Groundwater needs to achieve, quote, asymptotic levels over those 5 years. Groundwater contamination, it's very, very difficult, if not nearly impossible, for it to actually achieve zeros. So they will keep reducing down toward the standard over time. And once you've demonstrated that to DEC, they will be convinced as to the groundwater remedy. And soil vapor, you meet the Department of State's guidance document requirements. Part of the former regime was, you would propose a track 1 in your RAP, and DEC would frequently, or DOH would frequently come back to the development team and say, it feels like, based on the remedial investigation result, they might determine that, oh, there's a lingering risk of soil vapor exposure due to some contamination found on site that will be dealt with as part of the soil remedy. But the potential of that risk, for example, Department of Health might want a post-remedial soil vapor intrusion evaluation, and that requires you to have a building partially constructed with the first floor enclosed and the HVAC system operational. And that timing doesn't necessarily, you might not have your building sufficiently constructed by the time of your COC, and therefore you need to do it following the COC, and DEC needed an enforcement mechanism to have you do that post-remedial soil vapor intrusion evaluation. So DEC would require you to include in your RAP that you would aim for a conditional track 1, include that fallback track that you would revert to if you were unable to do these post-COC things, tasks within 5 years. And then, you would go ahead, try to do everything for the soil remedy and get your track 1 COC, and then complete the couple of remaining things you had to do afterwards. A big part of this conditional track 1 program was that you had to essentially have your fallback track fully in place. You had to have an environmental easement recorded on title by the time of your COC. You had to have a site management plan that was approved and ready to go. And if you happen to achieve a true track 1 by the COC, you could, eliminate that easement that you had, the contingent easement that you had recorded, for example. So there was a lot of fitting pieces together to ensure that you had this fallback track, a restricted track, in case you could not demonstrate track one unrestricted use at the time of your COC or within 5 years. Now they're pivoting that whole framework and just saying we are convinced that you have hit track two. There is lingering soil vapor and groundwater contamination or some other thing that needs short-term controls, and we're going to consider you as track two until you demonstrate to us that you've hit track one and we bump you up.
Okay, thanks. That's super helpful. So there's ongoing activity essentially to try to get to track one through to groundwater treatment or soil vapor mitigation measures. Okay. So sorry, Aaron, I interrupted you.
Well, just to follow up on that though, Kevin, have you seen, because especially the past couple of years, we've seen a lot of conditional track ones. I haven't seen a reissued unconditional track one from there. Like, has that process actually worked, or is that part of why you think this change had to happen from DEC's perspective?
So DEC would not formally reissue your COC to get you from conditional track one to true track one. This is not, this is an administrative construct and not a thing that was really reflected on the COCs. A conditional track one COC looked like a track one COC. And you just were obligated by your environmental easement and site management plan that you had to complete ahead of COC as part of your, fallback contingency. You were obligated by that to complete the post COC activities, and then you were, communicate with the project manager, have the consultant communicate with the project manager, and demonstrate that we have met those post remedial objectives. And then you would get their concurrence to extinguish the environmental easement that you have already placed on title as part of your fallback. And so basically bumping you up from conditional track one to a true track one would be demonstrating that you met those post-remedial conditions and then removing those fallback requirements, the SMP, terminating the SMP, extinguishing the easement, and then you would be left with what is a true track one. So it was not really a formalized process resulting in a new COC. The new regulations, you will get a reissued COC, a modified track one COC. The face of the document itself will change.
Yeah. So I guess an interesting way to look at this is kind of what you said, how in the conditional track one, you got a track one, including for tax purposes, which was kind of important. So kind of what you were mentioning at the beginning, like you have these different cleanup tracks, and those different cleanup tracks can dictate how generous the tax credits are going to be. Sometimes not just for the cleanup, but also for the building credit component, as we, most of us probably know, but, generally speaking, there's, a cleanup credit, a remedial credit component. There's two components of it, actually: site preparation credit component and on-site groundwater remediation credit component. Those are generally the remedial credits, and that is dictated, basically by, what is the work you had to do once you got on the BCP program to achieve the track that you achieved for your COC. And then there's also, after that period, you can get, a tangible component for the building, which, if you're in New York City, you have to meet certain eligibility requirements. And that also, I think, will be discussed a little bit later on due to some of the other changes here. But for the site prep and this kind of whole conditional question, the important thing was, track one unrestricted, you get a 50% site preparation and on-site groundwater remediation credit component credit percentage. Whereas, if you get a track two restricted residential, that's a 40% credit. Track four restricted residential, that's a 28% credit. So, the cleaner the site gets, the better the credit you get. So it was very valuable for these sites where they were having these challenges with groundwater and soil vapor issues, but otherwise they did a soil cleanup to track one standards, that they could get a conditional track one and they could get a 50% credit for their site preparation rather than I think often the fallback would be a track two, right? So there's a 10% delta, you'd get a 50% rather than the 40%. And then it's also valuable because a track one, it can also give you a 5% increase to the percentage for the building component, which can be, often in the order of magnitude of millions of dollars worth of, additional credits. So the old regime that, even though it didn't really exist, in anything other than the administrative, actions, it helped developers when they were building these projects to know that, well, when I get my COC, if I do a track 1 cleanup, I'm going to get my 50% credit, and I will also be getting my 5% bump up for my tangible, if you're eligible for tangible. And that assurance has kind of gone away here now that it's kind of flipped. Now, if you get a conditional track 2, you have this weird situation where a developer, you can do a track 1 cleanup, so to speak, all the activities, the remedial actions, the dirt you actually dug out, you did that all to track 1 standards, but you can only get 40% track 2 credits for those amounts. And I don't think there's any way under this new regime to kind of go back and, get that extra 10% later on. It's just not done that way. I'm pretty sure even in the new regulations, it says, when that modification of a track 1 does come, if it does come at all, that it's only effective from then onwards, right?
Yes,
and I think
yes.
the tax department would follow that as well. And functionally speaking, there's other reasons for tax that it's complicated, but that's a big deal. And, especially when you think about the timing here, I think this just adds a new question about timing for developers. For example, do you even go for a conditional track 2, or is it worth waiting and trying to get an unconditional track 1 so that you can basically get your 50% credit and get the 5% bump up for the tangible? And that enters into this whole analysis that I'm sure Phil is itching to talk about how do you even grapple with this? Like, how do you do the time value of money here? Is it worth, can you even guarantee, like, if you wait like a year, that you really think you can reach asymptotic levels, or could it be 5 years and that just throws everything out of whack?
Yeah, Jen made me promise not to put any spreadsheets up, so I'm not.
Okay.
So we're not going to do that. But I think this is a critical point. I mean, Kevin, what you said before about you can't really get, even if the testing reveals it, you're not going to get an unconditional track 1 for vapor until after your building is, at least the first floors are enclosed, and maybe your whole, depending on what you're building, maybe the whole building is enclosed and you're putting it into service. So that right away delays the certificate of completion. If you want to wait to get a track 1 instead of a conditional track 2. And so the math that Aaron is referring to is a business decision that developers are going to have to consider, is whether I want to take my conditional track 2 and take my tax credits today, knowing that I still have soil vapor to deal with, right? And that I'm never going to get, as Aaron said, I'm never going to get my extra credits for being track 1, even though I spent all that money to clean up the soil and I just have this little delta for soil vapor, this little delta for groundwater. So I'm going to defer my site prep credit claim, for a year or 2 years or whatever, until I feel like I can get that extra credit. I feel I can get to conditional track or unconditional track 1 status in soil vapor or groundwater. And I got to make a business decision in doing that spreadsheet analysis of whether it's worth the wait. And like Aaron said, it is a financial calculation, but it's real dollars. Because you're also, as Aaron said, you're also losing the 5% bump on the track 1 for your building. So you kind of have to, in the way it works, let's say if your COC is a year after your building's placed in service, the way it works is you're not getting any credits for your building until the COC is issued. You don't lose them like you used to under old law, but you have to wait to get your credits for the building. So the interesting thing is, and I think I know the answer, but what credits are you getting? Are you getting track 1 credits for your building or track 2 because you put it into service before you've achieved the track 1 standard and received a COC? So there are some loose questions around this that need to be, tracked down. And certainly there's zero guidance on the tax side from the Department of Tax and Finance on any of this. And we don't have experience with it yet. So,
yeah.
Well, I think, Kevin, I have a question for you about that, which is, we've seen a real push from DEC now to get sites through the program faster, right? And sites that had been lingering for a long time, DEC has been very emphatic that they need to get moving or they need to get out. So there's a question in my mind of whether DEC is going to let you sit with a site that's effectively remediated, but for the soil vapor and linger in the program for another couple of years. I think there's a real tension between this renewed interest in pushing projects quickly and, this potential incentive now to stay around a little longer to try to, maximize tax credits.
It introduces a lot of important timing considerations to think about from the outset of the project. You need to think about the entirety of the project, include through COC and your TCO. And you think about all that at the wrap stage, so you can actually understand, is it possible for me to try to get an unconditional track 1 in the first instance? Do I have to accept a conditional track 2? Is it worth the effort of trying to go for a conditional track 2 versus just a track 2, right? There's more effort required to get conditional track 2 because you actually, in effect, need to achieve the track 1 remedy. You're just not really going to get a track 1 COC until later when it gets modified and bumped up. And then, so it seems to eliminate an important financial incentive for developers to aim for track 1. When you are going to get a track 2 COC, you could just aim for track 2. If the finances work out and if that's feasible for your site, and all these site specific considerations you have to think about when you're developing your remedial action work plan. But so to be clear, a really important question I have, Phil, for engineering is there, let's say you get your COC, you conditional track 2 COC, you go and you meet groundwater and soil vapor contamination standards. That takes 2 years, right? So it's 2 years following your COC, and then you get it bumped up to a modified track 1. Is there any mechanism that you know about to claim those additional 10% plus in site prep credits?
I mean, I'll answer this, Aaron. You can give your views. My view is the tax law is silent. Doesn't talk about conditional tracks or any of these things. So there's not a mechanism by statute. And, from a policy point of view, the argument is, say, I did a track 1 soil cleanup. I should get track 1 credits, and it's always been a track 1 soil cleanup from when I got my track 2 conditional COC to when I got my unconditional track 1, my modified track 1 COC. So why shouldn't I be able to get the extra credits? But I think the way the credit claim process works, the way the forms are written, I'm not sure there's a way to squeeze that onto the forms. I'm not sure the tax department would accept it. You'd have to go back and amend, but for the tax period you're amending, which was the original COC year, you weren't a track 1 according to the DEC reg, according to the final reg here. DEC quote considers the site to have been a track 2 site, whatever that means. So, I think I don't think there's certainly not a clear path. I'm not certain there's any path to going back and recapture.
Yeah. So it brings it back to the importance of these timing questions at the outset of the project. You need to think about all of these things. And as Jen mentioned, DEC has taken a more sort of posture about progressing projects. In the new Part 375, there is a new termination regulatory provision, and one of the where DEC could potentially terminate a brownfield cleanup agreement if you don't adhere to the project timeline that you have told them and that the DEC has approved. That is a prong that they wrote into that new provision. And so now you are potentially at this point where you might want to wait. You might want to have finished your remedy and try not to get your COC to give that groundwater a little extra time to come down and try to get a true track 1 in the first instance. But at the same time, you can't push it too far because DEC now in their regulations can terminate your agreement for not completing the remedial program pursuant to the approved timeline. So it's lots to think about at an early stage in the project is my recommendation.
Yeah, the only other thing I was going to add for what Phil said is, like I said, the regulations mentioned that, like, if you get a conditional track 2 COC, it's a track 2, and then when you get the track 1, it's only from that point on of the modification that it doesn't apply retroactively or anything like that. And the way that the site preparation credits work is, you're doing all this cleanup activity and then you get your certificate of completion. The site preparation credits arise, as a credit claim item for that taxable year in which you get that COC. If you have a COC that's reissued and DEC saying it doesn't apply retroactively, like say 2 years later, I don't see how you can kind of match those two together. Practically speaking, there should be some kind of like, this probably should actually be, in the law somewhere. It shouldn't just be a regulation by DEC. There should be some sort of like a harmonization of like what the tax department and what DEC is doing here. But there just isn't. Practically speaking, all the brownfield tax credits pretty much go through a desk audit process. You could probably raise this on that process. We have no clue what that would entail, and I would never rely on that because there's nothing in the law that says that they would have to do this. But I could expect if you're caught in this situation, you will probably try to make some arguments during that process or potential protest, but that's not something I'd hang my hat on.
So before we move on, I have a question, Jen, for you and Kevin. What about grandfathering? Like, this regulation took effect just a couple of months ago. Like, is there any transition period for sites that, because clearly there are a lot of sites that went in thinking we had a conditional track one regime going on. Like, what's the problem? Are those sites all grandfathered, or does it only apply to sites that were accepted after the reg was final? What happened here?
Yeah. So DEC has written that, if I recall correctly, at least specifically with respect to soil cleanup objectives, which changed as part of these regulatory amendments, DEC has written that sites with approved remedies, meaning approved remedial action work plans and decision documents, those sites are grandfathered in under the former regulations. You meet the former SCOs, you can get a conditional track 1 COC if that was what the decision document says you were going to get. That was grandfathered in. There is, or maybe the transition period is currently closing now. I have one site that had completed its wrap public comment period, completed the public comment period in December last year before the new regulations became effective. But the processing of the decision document took a little bit longer. So we got a 2026 decision document for a conditional track 1 site. That might be potentially the last one of these that makes it through. The transition period, I think, will be very small. Here we are in March. I don't know how many other sites are similarly situated where they are right on the cusp of getting a decision document under the former regulations such that they would be grandfathered. I think now, if you have a draft wrap that you're submitting now, certainly it needs to reflect the new regulations. But if you had a draft wrap that maybe wasn't out to public comment, maybe you'll get a comment letter asking, update the SCOs, implement the new regulations, change your remedy from conditional track 1 to conditional track 2. I haven't seen one of those yet, but I am aware, like, there is a marginal number of sites that will get grandfathered in as their decision document is just during this transition period. But I don't know how long that transition period will extend from now.
Okay.
So Kevin, I think you're alluding to probably one of our next topics of conversation, which is these changes in the soil cleanup objectives, which by and large have all become more restrictive than they were previously. Maybe we can talk a little bit about those changes and what they mean for sites.
Yeah. So for the soil, there were hundreds of soil cleanup objectives that were changed as part of these regulations. As Jen mentioned, many of them decreased. Some of them decreased significantly. Off the top of my head, a couple that I know are the restricted soil cleanup objectives for the CVOCs. Many of the CVOCs went down significantly, 5 times or more, in the decrease. Some of the metals, some of like mercury and hexavalent chromium, which is the scary stuff, that went down also significantly, 5 or 10 times the decrease. So they're much more stringent, some of these SCOs. However, contrary to that, a lot of the PAHs, those are polycyclic aromatic hydrocarbons, those are SVO, semi-volatile organic compounds that are typically related with fill. These are like the benzo series, benzo-A-pyrene, benzo-A-fluoranthe. So those SCOs, the restricted SCOs, a lot of them actually went up, and some of them by like an order of magnitude. And so, and another a related thing a related change is that DEC eliminated the former regulatory definition of historic fill material. The two in conjunction, I take it as DEC is less interested in marginally contaminated historic fill sites from getting admitted into the program. It's harder because they eliminated this definition of historic fill, and now it's just based on the SEOs, and then they bump those fill-related SEOs up so that fewer sites will be eligible. A site that would have had, 1 part per million of benzoate pyrene, could have been eligible if it was widespread, but now I don't think it is anymore. I mean, I'm making these numbers off the top of my head for purpose of illustration. Don't count me. Look at the SEOs. Look at the regs. But so it's going to be harder to get in these just fill sites. There's going to have to be something else: petroleum, heavy metals, chlorinated, something else to get you eligible. And so I think we're seeing like a tightening of the eligible sites for the program.
It's an interesting question when you think about being grandfathered, because on some sites, you're being asked to chase protection of groundwater exceedances in the soil, all the way to the groundwater table for these fill constituents, which doesn't always make a lot of sense in New York City since we can't drink the groundwater anyway. So I could see a circumstance where you're in the program and you want to actually take advantage of these new SEOs to try to limit chasing some of those exceedances, even though, it may be beneficial to you in other areas. And obviously you're not going to be able to sort of pick and choose which new SEOs you want to comply with and which you don't. Phil, I think it looks like you were ready to jump in here.
No, I'm fascinated by this, by the notion that, some of the SEOs went up, and that, the thinking may be that we've got that's actually signals a shift in site eligibility. I guess, there's something else in the regs also around eligibility. What I hear, some attorneys and consultants talk about subjective eligibility. If you guys maybe could talk a little bit about that, I think that's going to be of great interest to developers.
Yeah, certainly. There's a couple of things in the regs that all, relate to the eligibility topic. One is the definition of brownfield cleanup or brownfield site, which it largely mirrors the statutory definition at this point. However, in the regulations concerning site eligibility, DEC codified this provision where a brownfield site is eligible for the BCP if it has exceedances of relevant soil cleanup objectives for its reasonably anticipated end use, which now DEC determines based on several land use factors and information provided by the applicant. But it used to be that the applicant would simply say, we're going to do this end use, and that was accepted. Now DEC will make that determination based on the information given to them. And that the proposed site, quote, requires remediation to achieve those applicable SCOs. That is the subjective part. It is a unilateral decision based on DEC's determination of the magnitude of SEO exceedances throughout the site, the geographic extent of them, the magnitude of exceedances of a background for the site. There's a lot of different factors that are in the regulations, but DEC will look at the data that you are now required to give them in what they call an investigation report, but phase 2, some amount of eligibility data that you have to give DEC showing that there are sufficient extent of exceedances above the applicable SCOs that your site requires remediation to be eligible. That does not mean that having a couple of marginal SEO exceedances will mean that your site gets into the program. They might determine that, oh, that's one, you're talking about 5-foot area here where you had one marginal, exceedance of one SEO. Like, they're not going to let you in the program. This is also this is essentially codifying a practice another administrative practice that DEC has been implementing for a while now. This requires remediation regulatory provision was not in the former Part 375, but DEC has been implementing this for the past couple of years. And sites with clear data-driven SEO exceedances were rejected from the program because DEC did not view them as sufficiently contaminated above the cleanup standards. Applicant teams will have to really think about their data. Not every site that would have gotten last year will get in this year. That's just the facts.
And I think everybody, I think by now knows, no brownfield program, no tax credits, right? So this begs a question that comes up for Aaron and I, you know, more often than not, where you're dealing with large multi-lot sites. And the question is, you know, how do we're not going to use the existing tax lot configuration. We're going to use, we're going to consolidate the lots and realign the lots. You know, how do we align strategy for brownfield site boundaries in order to make sure that we're aligning the boundaries with our development objectives? So building A should be one, building B might be separately financed and built later, building C, again, down the road a little bit further. But I think what's important, and there's tax credit planning that goes on inside those discussions, obviously, as well as logistics and staging. But maybe the threshold question goes to what you were just talking about, which is, what are the standards, and is there now sufficient, levels of contamination in the planned brownfield sites to quote, require remediation as the standard? Like, how does a developer get their arms around whether it requires remediation or not? Is there anything more than just what's in the reg?
Based on what's in the
I see you
reg,
smiling.
The regs give the factors that the DEC considers. Again, magnitude of exceedance, the number of exceedances, all these things. But it's clear that there has to be some widespread condition that is not just marginal contamination. That it requires a deep site-specific analysis. Talk to your consultant teams, but that is how I would describe the basic rule. And also, with your question specifically about different tax lots, the past couple of years, my experience has been the DEC requires some contamination requiring remediation on every tax lot of your brownfield site. Every tax lot should be independently eligible, even though it's a voluntary program where the applicant defines the site. We're in this weird realm where sometimes DEC might not let one tax lot of the assemblage into what will be a single development site into the program because it doesn't have contamination. And corollary is if you're splitting up a site and trying to rearrange things after the fact, then if you're trying to split for some reason a site from 1 into 2, which is possible if there's good justification for it, both sites will need to be independently eligible for the brownfield program. You can't just split off the cleaner parcel and then start building on that, doing minimal work. They need to both be admitted as independently eligible and then would have to remain independently eligible depending on however you do, sequence the phasing and draw the lot lines and all that.
Interesting.
But one thing that DEC will do is let an entire lot in, right? So I have not personally experienced them trying to draw a line and saying, okay, we're going to draw this box around the contamination and make you do a meets and bounds description, and that's it.
Right.
So they will let a full lot in, even if you don't have sort of evenly distributed contamination across that whole lot.
Okay.
Segueing into just another kind of related topic, not about site eligibility, but there is another important eligibility provision in the regulations. So now DEC wrote in when a site is not eligible for tangible property credits. And one of them is something that has been being implemented for the past couple of years, and it's in the statute. But it's if a site has been previously remediated for its then intended use, that site, or at least that portion that was previously remediated, is not eligible for tangible property credits. And DEC will make that determination on your initial brownfield cleanup agreement. But they will caveat that language with language saying that you can demonstrate that there's additional contamination that was not remediated, and therefore, you can petition DEC to not deem that portion of the site previously remediated and therefore eligible. It would reinstate eligibility for tangible property credits, and this can be done anytime ahead of the COC. And we've done that a couple of times for some of our sites.
So Kevin, if a site was remediated, let's say there was a petroleum spill was remediated to a commercial standard sometime in the past. Now you're coming in, you want to do restricted residential development. That increment of cleaning it up from commercial to restricted residential, just
Yeah, it
lost dollars.
the key inquiry is, it's previous remediated for its then intended use. If this site, in this hypothetical that you're talking about, if the site was zoned for commercial and was for commercial use and was previously cleaned up under the spills program to commercial use, that portion of the site DEC would say is ineligible for tangibles if you took it into the Brownfield Cleanup Program, even if you need to do additional remediation to take it to that next use, use level of restricted residential or whatever. So even if you need to do, you can generate site prep credits there because you need to do additional work to additional site prep work to clean it up to your actual brownfield end use, but you won't get tangibles because it was cleaned up to its previously remediated to its then intended use. It's possible to petition DEC again based on new data showing that the previous then intended use standards were not achieved. And so you'd have to basically go, it's a demonstration that the assumption is wrong. It was in fact not previously remediated for its then, that you can give them data collected during the remedial investigation throughout the course of the program and potentially convince them to reinstate eligibility.
And is that an ineligibility applied to the whole site or just to that specific area that was subject to prior? Did they draw a line around where you previously remediated?
I have personally seen DEC take the position that an entire site or an entire lot is previously remediated, but you can, if you have the data and the records and can support your argument, you can have them shrink it down to a portion of the site.
That must be fun when it comes to audit, Phil.
It is.
Yeah, we're dealing with what we call those donut hole sites. And because there's a donut hole of tangible credit ineligibility, the building is sitting over the whole site and sits over the donut hole. So we have to literally carve out a chunk of the cost of the building based on what's sitting over the ineligible portion. So good question. And yes, I think that is, it's a wrinkle. Thankfully, it seems to be a fairly rare occurrence. So, but you don't just build a building around the donut hole. It's over the donut hole. So you kind of gotta do some math. But that's
maybe you build a garden in the center of your building, just a whole little thing. So I was curious, Kevin, like how hard is that standard to overcome to show like, oh, well, they didn't actually clean it to the intended use? Is that like a really tough burden or is that, handled in, more casual manner?
Yeah. So, initially, let's say I'm working on a site and it's in this scenario, I might hear from the project attorney ahead of seeing seeing DEC issue the BCA that they have determined that this portion or the site is previously remediated. And I would use that opportunity to try to, rally the historical data and the administrative record from the spills case or whatever, and the zoning record and try to fit all the pieces together again to overcome that presumption that they're asserting that it was previously remediated for its then intended use. And again, the then intended use is the important part. You can't just say, there's still exceedances of restricted residential because that's what I want to do. You can't do that. You have to show that the site was not actually previously remediated. So it's like a little bit of a historical research kind of investigation, but it is possible to convince DEC before issuing the COC, and then they will issue it without any, tangible restrictions like that. But then if they do issue it with some previously remediated exception, anytime before the COC during the site remediation and investigation process, you can provide DEC additional data to show this site should have hit commercial. You told us based on your spill record that this site has achieved commercial standards 10 years ago, but we're finding contamination still above commercial standards in that area. Therefore, it was not previously remediated for its unintended use. So it's a data-driven process. If there's sufficient data, you can convince them ahead of the CUC. But if there's not sufficient data, or if it's only one data point that contradicts the presumption, you might have an uphill battle.
So we are coming up on the hour. I know we had wanted to do some Q&A. We have not seen any questions in our Q&A yet. So if folks do have questions, we'd love to solicit those from you so we can respond to them. I think we would be remiss in not talking about one of the, I think, pieces of good news to developers, which is the site cover definition. That pendulum has swung back and forth a couple of times in the past. So if you guys want to walk us through where those stand today and how that'll affect tax credit eligibility, that would be great.
Okay, I'll do the little intro with the environmental stuff. So there was previously not a definition for site cover system, and as a refresher, a Track 4 restricted use remedy requires a site cover system as a permanent engineering control, as it's just part of the remedial track. So all Track 4 remedies have site cover systems, and this was not defined under the former regulations. In the December 2021 proposal, which never became effective, there were two proposed provisions which face some criticism from the regulated community, which were soil cover systems would have required recognized only soil cover. So hardscape was not recognized. And on top of that, in your remedial action work plan, before you go and implement the remedy and do all the work, DEC would have required a binding cost estimate for your cover system, which only considers soil. And so
a hypothetical cost estimate.
Hypothetical. So you would have been, if that regulation had become effective at the RAP stage, you would have had to very carefully think about your eventual soil cover your site cover needs, figure out the unit rate of soil that you need for that area, and figure out a binding cost estimate that you would not be able to claim site prep credits above that, even if you incurred additional, even if you actually incurred costs above that estimate, it would have been binding. So that was never effective. But now here in the now effective regulations, yeah, as Jen said, it went almost all the way back around. And so the binding cost estimate requirement never went into effect. That's not the current regs. And now the new definition of cover system or site cover system explicitly acknowledges that hardscape, building foundations, asphalt, pavement, all that stuff that is part of the development that has a dual purpose in serving as site cover as well as development functions, that can be recognized as qualifying for site prep. And there's also, certainly, there's details on the technical specifications of what the thickness for restricted residential, you need a 2-foot thick soil cover equivalent. For commercial and industrial, you need a 1-foot thick soil cover equivalent. But importantly, the definition explicitly recognizes hardscape.
Yeah, I mean, it struck me as so odd back in 2017 and 2018 when the tax department started asking us, well, you can't count your foundations. You need to go get, and this is on audit of a credit claim where the final engineering report said that your cover system was your foundation and your hardscapes, right? And they said, well, go get us the cost of, 2 feet, if it's residential, 2 feet of material. And that's going to be your site prep cost. So in a way, even though the proposed regs, called for this binding estimate in the RAP, and those were not implemented, they were actually doing it in practice on the back end of projects for years. We had a lot of clients that had to go, get a quote for the number of, square footage that the building footprint occupied to cover it with 2 feet of clean fill, et cetera. So those proposed regs were a reflection of what DC and the tax department had essentially decided they were going to do. And so, as Jen said, this is really a welcome change that now they've abandoned this notion that the only cover system is soil and everything else is a substitute and doesn't count within the regulations as a site cover system, which was this nonsensical fiction that they made up to save tax credits. That's all gone. DC has said they're out of the tax credit business. So, Aaron, if you could chat a little bit about like where we are now with the new regs and how we're dealing with cover systems today.
Well, I was just going to add a little bit of color here about how this, I think, was part of, DC had to define cover system for basically these brownfield sites because The old generation 2 site preparation definition was much more expansive. It pretty much was like, what are you doing to prepare a site for the erection of a building? That's, don't quote me, that's not exactly what it says, but basically, you're just preparing the site for the erection of a building or its components. And so I think you saw probably some aggressive credit claims where, massive foundations were claimed, and I think that was noticed. The 2015 law change, site preparation definition changed to be, costs chargeable to a capital account that are necessary to a site's investigation, remediation, or qualification for its certificate of completion. And then it gives a long laundry list of a bunch of costs that are pretty much, always eligible, subject to the necessary and capitalization requirements. But then it mentions specifically for cover systems, cover systems, consistent with applicable regulations. And then it also says at the end, cover systems to the extent that they exceed, what's required in regulations are ineligible. So it suddenly became very important. Like, well, okay, well, what are these cover systems? And Phil's totally right. We, before there were clearly these discussions in the agencies about what it meant. And you had this fictional 2-foot clean fill being forced on sites where they had to build expensive, foundations. And it didn't really make sense, but that's what was going on. This change has been very welcomed, because now we've seen the tax department back down from this. We kind of feel like they shouldn't have imposed that in the beginning because those other regulations were being talked about and then they were proposed and then they were never adopted. It's a little unfair that some taxpayers were forced to comply with them when they were never even adopted. But these new cover system like definitions, like you said, they pretty much make it clear the hardscape should be eligible as long as consistent with, building code, fire code, all that. The real question now is more about, well, you still have to fit into this, necessary for investigation, remediation, or qualification of the COC requirement. So what we found to be very important is just like pretty much every site preparation cost, the remedial documents need to be descriptive of what the cover system is, what thickness, if possible, that is required, or what minimum thickness is required, for instance, from the building foundation as the cover system, because that language is, you can directly point to that, and the tax department in the past year or so has been allowing those costs in with no objection, I believe. And Phil and I actually had a case where before these regulations were adopted, but when the old proposed regulations were, lapsed or they withdrew them, and then these were in the as proposed regulations, we were able to protest a denial of a building foundation, and the tax department, so fully engaged with us on, that kind of rationale, and they agreed with us and let in, they had 6 inches of concrete, I think was what the FER said, and we got like a statement from the general contractor, like this is the amount of cost for that amount, and they let that in no problem. And I think that's what we're seeing going forward, but it is important to just, note that, the FER, you just want to articulate how much you think might be necessary, because the tax department, absent that, could still ask the question of like, how much was necessary, and that's a rabbit hole we want to avoid going down.
Right.
Yeah,
We always want to
underscoring
point.
the importance of
Yeah.
careful documentation, distinguishing remedial and construction elements.
I was just going to make the same point. I think,
Yeah.
A very detailed description of the quote engineering control, because, the critical part to me of the cover system definition and the final regs is that it is an engineering control. It starts by saying a cover system is an engineering control right away that says, look at the final engineering report to determine what that engineering control is, how it's described, look at the drawings, and then go back to the client and the engineers and the contractors and say, this is the engineering control, how much did it cost, right? Which is how we get the dollar amounts into the site preparation credit claim. So the better sorry, go ahead.
An FER, Phil, that said the foundation is going to serve as the cover, and you had a drawing that showed a 5-foot slab. Do you expect to get pushback from,
I think
on audit, that's, more than the 2-foot cover, or as long as it says foundation and that's the drawing, you get the full amount?
if DEC, I think tax can't, they certainly are technically cannot second guess DEC's determination of what an engineering control must be. right? So if the FER says your engineering control, you've got whatever muddy site conditions, unstable soil, you need this 5-foot slab in order for this to be protective of human health and the environment. If that's what DEC agreed to in the FER as the description of the engineering control, I would argue that tax has no basis to say that that's not eligible for site prep costs, because the engineering control, going to what Aaron said, is necessary to effectuate the remediation for the site and to qualify the site for the certificate of completion. As odd as it sounds that a 5-foot mat slab could be a full engineering control, but it also may be that in the discussions between DEC and the consultant, DEC may say, well, okay, you have, the 5-foot mat slab is not all engineering control. As Aaron said, maybe only 6 inches of it, or a foot, or 2 feet of it is, and the rest of it is a construction element. Who knows? I mean, that's a technical discussion beyond my ability to discuss as an attorney. But we will rely entirely on what's in the FER, and tax should also.
Okay. So Kevin, I know you talked about this distinction between remedial and non-remedial costs, and I think these regs may blur that line a little bit in terms of the new change of use and work plan requirements. So if you want to explain that change, and then Phil and Aaron, if you can talk about what that means for tax credit claims, that would be interesting to hear.
Right. Under the former regs, each remedial program, Superfund, State Superfund, BCP, ERP, had its own slightly different, but basically the same definition of change of use. DEC has taken all of those, consolidated them, and put them up in section 1.2, the general definitions for all Part 375 programs. So that's nice. So now we don't have to deal with 3 different definitions. The regulatory definition change of use is mostly the same as before, except that it now includes tax lot modifications as a type of change of use. This is not in the statute, but in response to public comments, DEC has stated that they view this inclusion of tax law modifications as necessary because such changes can impact institutional and engineering controls required by a site management plan. So it's in the regs. You now have to give change of use notices for tax lot reapportionment, which you did not have to do last year. DEC has also stated in its response to public comments that the tentative or preliminary municipal approval of the tax lot designation is when you should submit the change of use. So speaking for New York City, that is when you get your tentatively approved New York RP 602 form, tax lot reapportionment form. When you get that signed on the bottom part by the Department of Finance, then you can submit your change of use to DEC. You are still required, like under the former regs, to amend your Brownfield Cleanup Agreement to reflect the effective real property description once the tax lot modification has gone to effect and the municipal tax map has updated. So that's one thing. Just it's new. It's not much more than paperwork, so not a huge obligation, but just noteworthy that it is not found in the statute. The other big change for change of use is that any proposed physical alteration proposed in a change of use that is not activity pursuant to a DEC approved work plan now requires a change of use work plan for DEC to review and approve. And if you are doing activities that is captured in like your remedial action work plan or something, some other DEC approved work plan, instead of giving DEC a change of use work plan, you can direct their attention to the relevant portion of some existing other work plan. And last, if you are doing post COC work that is pursuant to a site management plan, you don't have to submit a separate change of use. You can follow the site management plan's notice procedure. So you don't have to duplicate if you're doing site management plan work. But so this is now a new requirement. DEC still does not approve the change of use itself, which is interesting. DEC acknowledges the change of use, but they will approve the underlying scope of work. And I've seen this in comment letters issued this year, which is an interesting distinction that they're making. But it's important that you provide this work plan, because otherwise you're not going to be able to proceed with your non-remedial development activity that you're proposing.
So Phil, if you need to prepare and implement a work plan for non-remedial work, is that required to get your COC and now a site prep cost?
I think, are you thinking of demo?
Or, you know, anything that you might be doing under these plans. I mean, if you can't do work at this brownfield site without an approved and implemented work plan, it seems that there's an argument that if they could kick you out if you didn't do it, it's necessary for the COC, right?
I think that's the argument, yeah. I mean, if DC's my argument is always if DC's making me do it, if I didn't do it, I wouldn't get a COC, then then the cost of doing it is a site prep cost, right? Because that's part of the definition necessary for the qualification of the site for the COC. I do have a burning question for Kevin though. So what is the acronym for a change of use work plan? Are we going to call it like a CHOP? What is it? I just need to know.
I would do.
Now that we have a whole new category of work plan, like what is this thing? So,
so another thing is that it's the exact form of this change of use work plan is not particularly defined. So I think it could take a variety of forms, but it certainly requires enough detail for the DEC, DER staff to review and understand what you're doing and approve a scope of work. So you can't just say the building's going to go down. You have to give them building demo plans.
And who certifies the work plans, Kevin?
Right. So can we talk about demo? Because this question does come up once in a while. People will say, well, I don't have an approved remedial investigation yet, right? Or an RIWP. I don't have an approved RAP, obviously, either, but I need to start demo. I have to, like I just closed, my affordable housing project needs to do the demo. I'm going to do the demo. I can't investigate the site without it, but now I need a work plan. And I'm doing it before I have an approved remedial investigation work plan, which might have mentioned that I was going to demolish the building to effectuate the RI, right? So the question I get in those, or we get in those cases is, well, is my demo cost going to count if it's not under an RI work plan? And I think now we have a COU work plan that speaks to demo. The question is that enough? Goes to your question really, Jen, right? Is that enough to make it site prep? And I don't know that there's a clear answer other than I think the logistics of doing an investigation or remediation, if those logistics require you to do demo, then obviously demo is a site preparation cost, right? And it's also on the laundry list that Aaron mentioned. So I'm halfway answering my own question, but but I think I want to point out for the audience that this is, this question does come up occasionally, and we have a new environment with this change of use work plan that we didn't have before, and we don't quite know whether that changes the dynamic. My sense is that it changes it more favorably because now DEC is signing off on a work plan, right? So
it's still not especially clear because the change of use. What DEC is approving is that your proposed physical alteration scope of work will not interfere with the remedial program. That's the approval that you're getting in a change of use. It's that you're not interfering. And so I don't know, it's TBD. We'll see how the change of use documentation survives audits, but it certainly gives another opportunity to include additional helpful language in the administrative record, perhaps a change of use demo plan. And then later, you could belt and suspenders it, put it into your remedial action work plan as well. It was necessary to do this. You can put it in both.
And in the FER.
Yep, and in the FER, certainly. Yep. So there's as an opportunity to just improve the administrative record, certainly welcome.
But do we think that, if it is an approved work plan, would we be obligated to recite our compliance with that in the FER, sort of regardless of tax credit implications? Will we be looking for that to be certified?
If the change of use somehow was remedial in nature, should be in your FER. But if it was purely remedial in nature, I don't think DEC would approve your change of use and would say some of it's a BCP work plan, not a,
Right. I guess I'm asking, would they require you to attest to the fact that you did the work in such a way that they agreed would not affect your remedy, right? Would they ask for some proof that you've done it in the way that you described to them that they were comfortable with.
I don't
guess
think
we'll
so.
see how this
Unless,
unfolds
yeah.
now that we
We'll
have
see
these
how it works,
requirements.
because I feel like what you're describing is more like an interremedial measure, right? Something that has a remedial purpose. It's an approved work plan and then results in a construction completion report as the closeout documentation. I don't think an equivalent of a construction completion report is required for a change of use. I think it is a preliminary and prospective approval only. But I've only seen a couple of these so far.
Yeah. I can't imagine they want more documents to review.
Yeah.
So
So
we got
we've
some
got about
questions.
12 minutes left and no questions. Are there other aspects of these changes you guys would want to?
I'm seeing some questions. Are you not getting those, Jen?
I
I
see a
am
couple.
not.
I see a couple too. Well, while you find this, I do want to talk about one other topic quickly. There are some additional tangible property credit gateways for New York City sites. As Phil described in our intro, these tangible property gateways have been a thing since Gen 3 BCP in 2015. Previously, it used to just be affordable housing, underutilized and upside down to start with. And they've expanded to include this if you are in a brownfield opportunity area and a disadvantaged community, and you receive a certificate of conformance from the Secretary of State with respect to the brownfield opportunity area. That's one. You have to have both. You have to be located in both and have the certificate to qualify through this gateway. So it requires a decent amount of work to get through. The other new one is a renewable energy facility gateway, but DEC's regulations require that a site going through this gateway has to be primarily used for renewable energy generation specifically. And so that opens several questions of how do you determine primary use of a site if it has more than, if it's not just a site with solar panels and it has something else, co-located batteries, a building, something like that. How do you determine the primary use? Is it based on area or dollars or nameplate capacity? Or I don't really understand how you determine primary use. But my impression is that the intent of this provision is to bar a redevelopment of a building with rooftop solar and accessory use from getting through this gateway and getting tangibles for the entire building, right? That's my impression of the requirement, but its implementation seems unclear. And then finally, the affordable housing gateway, it existed, but now there is a third prong that grants developers additional flexibility, because previously you had to demonstrate to DEC that you were affordable housing projects subject to a governmental regulatory agreement or restrictive declaration before your COC. And this led to a whole suite of issues with 421A sites in particular a couple of years ago, because those 421A sites are affordable housing projects, but they could not provide certification of such before the COC, leading to a whole bunch of creative solutions that people came up with, and eventually DEC recognized that affordable housing sites that were under 421A could submit an affidavit, a certification that they would be affordable housing and could get in through that gateway. But this was another administrative construct created a couple of years ago in recognition of a real intractable problem that could not be resolved under the current regs. Now, this third prong of the affordable housing gateway, it allows for sites that will qualify for benefits, including tax exemptions, to pass through the gateway. But you do need to have some kind of certificate of compliance from the Affordable Housing Regulatory Agency. So I'm not exactly sure what form that is, but it is certainly more flexible than requiring you to be subject to a restricted declaration or regulatory agreement as of the COC.
Yeah, no question.
So we do
That language was drafted in order to solve the problem with RPTL 421A sites and maybe now 485X sites. And for the audience, it's not knowing these numbers that we're throwing around, these are property tax abatements that are available primarily in New York City to but similar provisions apply elsewhere to housing developments that include a percentage of their units as income restricted units under a restrictive declaration as part of an affordable housing program that creates a property tax abatement, and it's administered by New York City HPD, but it's part of the real property tax law. So those were sections that we were talking about, and it did create this weird logistics timing problem. The DEC was very helpful in resolving in a practical matter, and then they kind of swept it up and fixed it to a degree with this additional provision in the 2022 Act. So, so should we turn to the questions? We've only got a few minutes.
Sure, I think maybe we'll do the easiest one first. So taking them slightly out of our order, we have a question about vapor barriers and sub-slab depressurization systems. And I think as a lot of us are familiar, DEC will refuse to allow you to call those elements engineering controls unless and until you've done the post-remedial monitoring that demonstrates the need to operate an SSDS. And so it sort of forces everybody to kind of install these passive systems, do that post remedial sampling, and then decide whether or not it gets turned on and is considered an engineering control. And there was a question about whether we foresee any changes in that based on these new regulations.
I really do not, unfortunately. I think that DEC's position will continue to be that a vapor barrier is always an element of construction, and they will always ask to see it documented as such, even though it is really part and parcel of the same system that is the sub-slab depressurization system. It needs it to work. But for whatever reason, this is they've drawn the line there, and I don't really see the overall framework in which you have to demonstrate your need for an active SSDS for it to count as an engineering control to still, I think that'll still be the case under the new regs. I don't think that anything really changed.
So Phil and Aaron, can you talk to the tax credit treatment for passive sub-slab systems once you've demonstrated that there's no need to turn them on?
Yeah, so essentially you have a question about which credit component those costs will be part of. So like we were talking about earlier, there's, the remediation credits, and then there's the building credits. And, the remediation credits get a higher percentage, help you build up the limit for the tangible credit. So they're often pretty important. And we'll see a lot of these sites where basically, the most common fact pattern we have is, a project will get their COC 1 year, and then they'll have their site preparation credit component claim, and then they'll place their building in service the next year, claiming all their building credits. And in these situations, what happens is, for the SSDS and stuff, you identify them, and you do not include them as part of the site preparation credit component, because per the FER and everything at that point, it'll say it is not an element of the cleanup. Instead, it's like an element of construction, usually pending some sort of, the soil vapor, intrusion evaluation to be done later on. And then basically the next year, there is a mechanism, the credits arise in the year in which you get the COC, but you can claim site preparation credits for up to 5 years after the COC as well. So it's not like you only have one bite at the apple for those costs. So you hold on to them because they're going to be either part of the building, or potentially they could be claimed as site prep in this next year when the building's placed in service. If you have the test and it says that it is remedial and it is turned on, then you can claim it as site prep. Otherwise, it becomes, as long as it's part of the depreciable basis of the building, which is usually what happens, has a useful life of more than 15 years, usually is the building, right? Then you claim it as part of the tangible basis instead. So it's not normally like completely lost. It's, but depending on the situation, it could, whether it's included or not, could be a big impact because of the site preparation 3 times limit. Because as we all know, for, most residential projects, the tangible property credit component is limited to 3 times the site preparation costs, or $35 million, whichever is lesser. So, if the SSDS is say $500,000, $600,000, $700,000, $800,000, and you're 3 times limited, whether you get that or not could be a big bump, right? So that's what I usually see. But I don't even know if I've seen one where the where the SSDS has been turned on later. Most of the time, there's been a couple where there's been SSDS that was required, and we claimed it initially at the first bite when the COC came out. But a lot of these ones where they have the testing later on, it seems like they're never turned on, in my experience. So they end up being a building credit basis instead. I don't know if you've seen something differently with that, Phil.
Same way.
Yeah.
Another question we got was actually with respect to the applicability. So Linda Shaw's asking, you know, the regulatory language, maybe does it clearly reflect what DEC is currently telling folks is their interpretation of the applicability here? And I think she's asking whether we think there's a way to argue that in fact the
So
RAWP may not be the trigger.
this is the grandfathering on the conditional track. Is that what you?
Well, it's really the applicability of the regs
of the
in
regs.
general, which, you know, would affect, I think, grandfathering of anything. But it specifically says that these requirements apply to any orders, agreements, STIPs, or contracts entered into after the effective date, and work plans, reports, certificates, and other remedial program documents approved, accepted, or issued after the effective date.
I think it's that last part, that and other remedial, you know, if you don't have an approved RAP and they can force you to adhere to new Part 375 in order to get an approved RAP, then that last part of the applicability provision seems to capture that. And, you know, that seems to line up with how I've seen them implementing this grandfathering. Except for the transition cases, which I think it's now.
It's a good question, because so the language that is in question is this provision that says the requirements set forth in this part, meaning the Part 375 regs, apply to any order, agreement, meaning a brownfield cleanup agreement is an agreement, right? Stipulation or state assistance contract entered into by the department after the effective date of this part. So we are certainly, if we have a brownfield cleanup agreement that is entered into before the effective date, meaning December 31st, 2025, that first prong of this sentence implies that these regs would not apply. But then it says, and other remedial program documents approved, accepted, or issued by the department on or after the effective date. So I think what the questioner is asking is whether those are two different rules, or whether the entering into the agreement is part, or the remedial program documents are part of the order, agreement, or stipulation that was entered into before, and there you'd be grandfathered. Because of course, we're talking about situations where you enter a brownfield cleanup agreement before the Part 375 regs were finalized, but the remedial work plan or other program document was approved after, right? So it's a really interesting question. I'm not sure how a court would answer that. It's a question of interpreting the regs themselves, right?
So we are at the end of time. So thank you to everyone who's hung in with us for the full 90 minutes. We put our contact information up on the screen. If anyone has follow-up questions that they'd like to take up, please feel free to reach out. Thank you all for joining. Have a great afternoon.
Thank you very much, everybody.
Thank you all.
Yep. Thanks, everyone.
Always
your
a
time.
pleasure to chat BCP.
Yeah, thanks, Jen. Thanks, Kevin.
Yeah, thanks, everyone.
Okay, bye all.
Bye.